Guys, Christine here. I just got back to my hotel. I just finished up in court for the day. Court is still going, but there is another party in this hearing, our legal challenge to British Columbia vaccine passports. This is our appeal. The other party isn't associated with us, so I decided I was going to head back for the day and I would tell you what happened with our arguments today. I also figured out that if I put my laptop in the window instead of facing the window, the light is a lot better. So I'm not as orange as I was yesterday when I recorded this for you. For the people who are viewing right now, can you just put a note in the comment section in the chat there to let me know that you can hear me? Because I don't want to start talking if no one can hear me. Okay, Sean M., thanks very much. So let me tell you what happened today. So yesterday, as you know, the government tried to fight us on even having this appeal heard at all. They had said that the appeal is moot and should be dismissed, but they failed. And this is one of those few rare cases where we're actually going to be hearing the appeal in a COVID era case about vaccines on the merits of the case. So this is a really big deal. So the court is just outside my hotel. It's this beautiful building, this kind of brutalist modern building. We're on the 6th floor. If anyone is in Vancouver and they want to come and watch it, we're in courtroom 60 on the 6th floor. So I also did live tweets of the hearing in case anyone wanted to follow along, but they weren't able to. You can read my live tweets. So the focus of the hearing today, since we defeated the government on their mootness application, today we got to the merits of the appeal in our case. And just as a little bit of background, although I think a lot of you already know about this, we have challenged the vaccine passport public health orders in British Columbia for failing to create a workable system of medical exemptions. Now, as I have said, we have broad concerns about the vaccine passport program, but we had really urgent and large concerns about people who couldn't be vaccinated for medical reasons. And if you'll recall, we had 3 women, actually 2 women and a girl who we were working with in this case. Their names are Erica, Sharon, and Veronica, and they all had good faith claims for medical exemptions, but they were not able to apply for medical exemptions. So we have Erica, who's a teenage girl who developed pericarditis after she got her first dose of the COVID vaccine. We have Sharon, who developed a condition called brachial neuritis, which is a paralysis of her arm after her COVID vaccine. And she subsequently got pregnant and didn't want to risk further nerve damage that could hurt her unborn baby. And her neurologist did say that this brachial neuritis was an adverse reaction to the COVID vaccine. And then our third person we were working with is a woman named Veronica, who's medically complex. And she had a number of different contraindications for drugs, has had many adverse reactions to drugs. She has mobility impairments. She has a lot of complex and overlapping disabilities. And she did not get vaccinated because she did not feel safe knowing her own history with her own body and with medications. She did not want to get vaccinated at all. And she was subsequently denied access to the public pool where she did her mobility therapy, which is really sad. Now, as I said, we have broad concerns about the legality of the vaccine passport for all members of the public, but we had this special and urgent concern for these women and for people like them who couldn't get vaccinated for medical reasons. And the fact of the matter is that the vaccine passport regime developed by the British Columbia government did not have workable exemption programs. At first, they didn't allow for any medical exemptions at all. We had to send a letter to the government for them to even create a process for applying for medical exemptions. After we sent them a letter, they did create this process, but the first process they created didn't allow for blanket exemptions. They only had activity by activity exemptions. Then the program required people to send in a doctor's note along with a form that had 6 tick boxes with acceptable medical reasons not to be vaccinated. And those 6 reasons were all kind of permutations of either anaphylactic allergies to a component of the vaccine, type of heart inflammation that was an adverse reaction like pericarditis, or if you were undergoing a particular type of cancer treatment. You could tick one of those boxes. So today, we are making arguments that the activity by activity exemptions and whether that process created by the government violated the charter rights of the women and girl in our case. And the charter rights that we were asserting were violated by this government exemption process, this flawed government exemption process. Those rights are Section 7 of the Charter, which is the right to life, liberty, and security of person, and Section 15 of the Charter, which is equal protection under the law and the right not to be discriminated against on the basis of a protected ground, in this case, disability. Now, the panel hearing the appeal was Justice Groberman, Justice Abreu, and Justice Skolrod. But as I explained to you what happened today, I'm just going to collectively refer to any comments made from the bench as collectively from the bench. I'm not identifying who made which comment, mostly because I didn't properly keep track of that. So we argued up until lunch today, and actually a little bit after lunch, and we began our arguments. Our lawyer is a lawyer named Jeffrey Trotter from Vancouver, and we started by addressing some of the questions that the court raised yesterday. They referenced the College of Physicians, which is the regulator of doctors in the province of British Columbia, and what the College of Physicians had said to doctors. And we gave the court this document. We showed this document to the court, showing that what the Public Health Office had said to doctors about the acceptable reasons for doctors to write a medical exemption note. Now, recall that yesterday in court, if you didn't watch the video yesterday, I'll just tell you now that we had argued it was hard for patients to get exemptions because doctors had been given what we call a soft warning from their regulator not to write letters for exemptions for conditions outside of that 6 tick box medical conditions: anaphylaxis, heart inflammation, or cancer treatment. Now, we also showed the court a statement Dr. Bonnie Henry that Dr. Henry made in response to a question from a reporter who was worried about, people getting fraudulent exemption letters. And Dr. Henry said that she was working closely with the College of Physicians and that we put out guidance, and that we, which is the college or the regulator of doctors and public health, have been working together. She said, we have been working together. And, the people involved in our case, Erica, Veronica, and Sharon, they saw these publications that the college sent, these letters that the college sent to doctors saying, don't give an exemption other than an exemption that is approved by the government. So what that letter said was, this is a letter that came out 2 weeks before Dr. Henry made this statement at the press conference that we, the regulator and public health, have been working together. And this letter is what we say Dr. Henry and the College of Physicians had been working on together. In our view, that letter that said only the acceptable medical conditions can be what the doctors fill out, that's what we say is public health's view on what an acceptable medical condition is for an exemption. The reasons in that tick boxes, those 6 tick boxes of anaphylaxis, heart inflammation, or cancer treatment, those are the only valid reasons why someone could have a doctor write an exemption letter. And, the College of Physicians, we say that is their interpretation of what public health had said. And the Public Health Office has said that they worked with the college. And this letter that they sent to the doctors, that was it. That was their interpretation. Those were the only valid reasons. There isn't an option to go outside of those valid reasons, to write something else in the government form that the government forces you to send in if you want an exemption. So this letter is what we could find online. And in fact, our clients' doctors had told them that they wouldn't write letters for something not on the list. And it's because doctors believe that this list that the government had approved is the only acceptable list of reasons. And the college, their regulator, had told them that. We had a lot of doctors who were concerned during this period about, straying at all outside the mainstream acceptable things you could do or say about COVID, because we had doctors who were facing disciplinary action for straying outside of that mainstream narrative. So the court asked, does that letter from the college, does it help us interpret the form, that tick box form, or was that letter from the regulator, was it used by by the three women in our case to interpret the documents? And we said that, the court should consider what Dr. Henry has said publicly, that they worked with the regulator and that they seem to have adopted this closed list approach. Part of our argument is that there was no open category for medical exemptions. So people like Sharon, who had a rare medical reaction, or Veronica, who had a medically complex situation, they didn't have one of those approved reasons to get an exemption. So they weren't even able to apply. So let me just go through my notes. The court then raised the issue of Erica. Now, Erica had pericarditis, which is one of the approved reasons. So what the court said is Erica's complaint isn't that she wasn't on the tick box. She did have one of those reasons that the government had all pre-approved, but she couldn't get a blanket exemption. She could only apply for exemptions on an activity by activity basis. And the court said, let's see, let me go down here. You know what? I'm going to get to what we argued on Erica, because there's a bunch of other things in my notes here that I want to talk about. So one of the things is that the lower court in this case dismissed Erica, Veronica, and Sharon's claim as what they call premature, because the lower court said that Erica, Sharon, and Veronica could have used the public health exemption process. But we say that process wasn't available to them, and it certainly wasn't clear if it was available, that it wasn't obvious that it was available. And in fact, the face of the regulations of these vaccine passports, the face of it meant they were actually not available. And the court says, the court asked us, couldn't Erica, Veronica, and Sharon have made inquiries about whether or not they could have applied? And our position is that the forms are clear. They say what they say. There's no reason to make an inquiry because they didn't have a condition on the list. And the forms didn't make some option that you had an alternative. So that's when they asked about Erica. They said, Erica had pericarditis. Why couldn't she apply? And, our position is that Erica's case, she has a listed condition, but she was only eligible for that activity by activity exemption. So there was no point of inquiring at all. There was no point because the order said what they said, and that's why we sued the government. And after we sued, this is what's so crazy. After we sued, Public Health sent us a letter, sent our lawyer, Jeffrey, a letter to give to Sharon, Veronica, and Erica. And in that letter, it said, we know that the orders don't say this, but Public Health is actually giving these blanket exemptions that Erica wants. And we're also giving exemptions to people who have conditions not on the list, the 6 tick boxes. So the problem is what that letter said that Public Health sent us, it wasn't in accordance with the orders. When Jeffrey got that letter, he said he immediately looked up the orders, the rules on how the vaccine passport exemption process worked. The order in force at the time that he got this letter said you can only get an event by event exemption. The order itself didn't allow for blanket exemptions. So Jeffrey said when he checked that letter against the order and he saw that it wasn't compliant, that they didn't make blanket exemptions possible, we proceeded to sue the government. So we filed the lawsuit. And this is when the court asked about Veronica. So the court said, isn't Veronica self-diagnosed? And two of these patients had adverse reactions, but Veronica, she never got the first dose because she was uncomfortable with the safety level of the vaccine for a person who had the type of disabilities that she has, including spina bifida, including her history of drug reactions, including the many surgeries that she's undergone. She's just very complex. And the court asked, so Veronica never got a first dose and never went to the doctor to get a letter. But, she went to her doctor and her doctor didn't give her a letter. The court said in a, kind of maybe condescending way, but Veronica says she did her own research. And the court said, I assume that means she went online, and it's not that her doctor didn't tell her don't get vaccinated. It's that she says, I did my own research. I mean, I take issue with this because part of Veronica's issue is that she has a very unique body. She has a very unique history medically. And we should take Veronica at her word that she knows her body, she knows her history. And saying she did her own research in this way kind of suggests that she was reading online conspiracy theories. But the reality is her research and her own is part of her research is her own knowledge of her own medical history and her own sense of how her body reacts to things. So we said, Veronica saw her doctor. She did talk to her doctor about vaccination, but it was a non-starter because she was not on that list. The court said, but no doctor said to her, don't get vaccinated. But we don't know the answer to that, because the evidence that we have is that her doctor wouldn't even consider it because she wasn't on that list of approved conditions from the government. So Veronica's evidence is that she believes she wouldn't have been safe to get the vaccine. The court says that that is opinion evidence, that this isn't an evidentiary basis for her to get an exemption, because she just wouldn't apply. And this is kind of missing the point, because the case is not that the court should now order that Veronica get an exemption. Look, that the vaccine passports in British Columbia ended 17 months ago. The issue in this case is that the orders, the vaccine passport orders, didn't allow Veronica to apply at all. And all Veronica is asking for is a world where she can go to her doctor and just get considered. And she couldn't even get considered by her doctor because she didn't have a condition on that list. What we can take away from Veronica's evidence and from her affidavit in this case is that no one would consider her because she wasn't on the list. And we then turn to the issue of the standard of review, which I won't get too much into, because that is an issue that gets complicated pretty quickly. But the point of this case is that the challenge isn't to any particular decision about whether or not to grant someone a medical exemption. It is against the vaccine passport orders themselves. And if someone in public health was issuing, which is what the government has argued, that someone in public health was issuing exemptions anyway, blanket exemptions, and exemptions to people who had conditions that were off of that approved list. The fact that someone was doing that contrary to what the order said is actually just evidence of illegality. It doesn't save the orders. So then we pulled up, some case law. There's a famous Supreme Court decision called NER, and the court said, if we were to find that the order and the forms meant that public health couldn't give these exemptions that they were in fact granting, then we don't even need this case law. The difficulty the court said that they were having was whether or not that's actually what the order said. And we argued that, if there's an unconstitutional law, it shouldn't stay on the books. And the exercise of secret discretion by public health doesn't save that. And the court agreed. They said, yes, that's a straightforward interpretation of the law, and that is a good thing. what we say is that the divergence between the law on the books, the public health order that was actually enforced that said no blanket exemptions and people off this list cannot get an exemption, that divergence between the law in the books and the law as applied exacts a cost in the coin of injustice. And that's a quote from a Supreme Court decision. So we argued that in the case of Erica, who's that teenager who had pericarditis, what the public health office was doing was clearly something inconsistent with the orders. The order said activity by activity exemptions only, and they claimed that they ignored this language of the order and they were just giving blanket exemptions. And the first time that we would have even known that they were doing this was when they told us that in the letter, because we sued them, not because they went out of their way to make any public pronouncements. They didn't say, oh, it seems that there has been some misunderstanding of what these orders mean. Let's clarify for everybody, just so you know, if you've had an adverse reaction to the vaccine, you can still be treated like like a vaccinated person. You can still go about your life. We'll treat you just in a non-discriminatory way. We'll treat you just like you've been vaccinated because you had an adverse reaction. We want to be fair. They didn't do that. They didn't do that at all. They secretly granted exemptions while saying they wouldn't grant exemptions that were on a blanket level. Every time you wanted to leave your house, go somewhere, go to your grandma's house, go to the mall, you needed to apply again. No one found out until our legal challenge was fined. So, at the lower court judge still found that Erica's claim was premature, and the lower court Justice Hinkson, dismissed Erica's claim as premature because he said, public health actually was granting these blanket exemptions, even though the order said that wasn't available. And we say that can't be permitted. And the court in this case said, well, the public health office eventually amended the form and Erica got what she wanted. So she could apply for a blanket exemption. But what Erica wants is for the government to actually acknowledge that her rights were breached and know that the government will not treat her or people like her like this again. So then we went kind of into detail about what this event by event or activity by activity exemption looks like. The court asked, if Erica wanted to go to a friend's house, is that an event or is that a type of event? How many exemptions would she need to apply for? Is it, could she just apply once for all friends' houses? Can she apply once for each restaurant? But the way the form works is that you need to fill out a form. You need to give the date for your event or activity. You need to explain the importance of the activity to you and why you can't do it, remotely. And the court asked, could you just put in, like from the start of the month to the end of the month, a long period? The form isn't clear, but maybe, isn't it a stretch that how many times would you actually have to do it? And we said that she would have to do it for any type of activity she was seeking to engage in. So the court went through Erica's affidavit, which describes the kinds of things she wanted to do, which was go to her grandma's house, go to her boyfriend's house, go to her friend's house, go to the mall, go to a craft fair she wanted to go to restaurants, very dangerous stuff. The court has to keep us safe, or the Bonnie Henry needs to keep us safe from Erica going to a craft fair as a only one-time vaccinated person, very dangerous. Like, let's make her apply each time. But the court said, when you count all of those up, those things she wants to do, that just seems like 6 separate applications. Like, apply once for your boyfriend's house, apply once for swimming. That was another thing she wanted to do. Based on what you're saying, she'd only have to apply 6 times. And we said, when it comes to the charter, we're talking about someone with a disability who already experiences higher levels of social exclusion. And the test under Section 15 of the charter is that there's a differential treatment because of a disability. And then the court said, well, this isn't differential treatment because she's disabled. it's a differential treatment because of her vaccine status. But no, the reason she can't be vaccinated is because of her disability. This is what we call a facially neutral law that has a differential impact. And we said, she can't, as a right, as we all are free to do in society, Erica cannot, as a right, go to meet with the closest people in her life to do the most important activities in her life. And the court said, well, this just seems like this is probably the craziest exchange from today, by the way. I got pretty riled up. But, I wouldn't read into what the court was questioning us about necessarily, because sometimes questions are just trying to shake loose an argument rather than an indication of where the court is leaning. But I will tell you that this exchange I'm about to tell you about got me a little agitated. So the court said, we were saying Erica can't meet with the closest people in her life for the most important activities of her life without getting government permission. And the court said, this is just the inconvenience of filling out a form. And we said, no, she's essentially under house arrest because of her disability, unless a bureaucrat says that she can leave. And the court says, well, she didn't apply for an exemption. And there may be, 6 different applications she would have had to filled in order to go outside of her house. And that doesn't seem to be a huge burden and inconvenience on her part. But we're claiming that there's a fundamental violation of her rights because she had to fill in a form 6 times. And we said, no, this is a conflation of Section 15 of the Charter that guarantees her right to be free from discrimination, and Section 1, whether that discrimination is justified in a free and democratic society. And the court said, no, I don't know that even her rights are violated. She did have an entitlement to apply for an exemption, but she didn't pursue it. And that's not true. Erica's evidence is that she wanted to be treated like a person who was vaccinated. She just wanted to be treated like the regular other people. And she had a legitimate reason not to get vaccinated. And the court said, well, why is it such a big deal if she needed to fill out the form 6 times instead of 1? Well, the thing is, even if she did that, even if she filled out the form 6 times to ask for 6 different exemptions, that still doesn't cover the things that come up on short notice. Like, for example, a funeral. What would the chance be that public health would rule on her new exemption application for a funeral in time for her to actually go, especially when we know Bonnie Henry announced that she had stopped considering exemption applications at all for a period. And also keep in mind, Erica was 17 or 18 at the time, and we're sending this 17-year-old to deal with the government and a bunch of bureaucrats every time she wants to do something like see her boyfriend, her grandma, or go to the mall. The court says, well, the evidence is that it's just those few activities, the craft fair and her swimming lessons. And we said, there were 6 things that she was thinking about in the moment that she filled in that affidavit. But there are other things that come up. And our lawyer asked the court, how many times have you done in the last 10 days that you didn't know about in advance? How many times did you have to leave your house and do something you didn't know in advance was going to happen? Did you have to seek permission every time you did that? That isn't trivial. So on Section 1, that's a different issue, but we do think that her rights were certainly violated. Then we took the morning break. That's about 15 minutes. I did a little walk around the courtroom. And then we came back following up again on Erica's situation, the girl with pericarditis. So Jeffrey, our lawyer, said if Erica was serious that this was a significant impact on why she didn't apply once she got the letter that there was a blanket exemption. So the court had asked, why didn't she apply once they said that we are granting these blanket exemptions? They told us she actually could apply, even though the order said she couldn't apply. Why didn't she do it? Well, the way the court process works and the legal process works is if Erica had applied for that partial exemption, she would have lost the opportunity to challenge the orders themselves. And that's the law as it's set out in another case called Baudouin. What Baudouin found was that if you use the administrative process, you could never attack the orders themselves. And that would have happened to Erica too as well. We wouldn't have been able to go to court and had our lawyer represent Erica if she'd done that. And the court said, well, because Erica would have gotten what she wanted, isn't that good? But no, she only would have been given part of what she wanted. She would not have been treated equivalently to a vaccinated person. So we had about 55 minutes left at this point, and that's when we turned to the pure charter argument. So as I said, we are arguing section 15 of the charter, which is the right to be free from discrimination and the right to equal treatment under the law. And this vaccine exemption program, it had a differential impact on people with disabilities because they were not treated the same as people who were vaccinated. And then the other thing that we were arguing was section 7 of the charter, which is the right to life, liberty, and security of person, and to not be denied that protection except as in accordance with principles of fundamental justice. So we first addressed section 15 of the charter, the right to be free from discrimination. And we started by saying public health was actually already aware of equality concerns about vaccine passports because before they were brought out, I think a month before, Bonnie Henry originally said she was not going to bring in vaccine passports because they would increase inequities. So she was well aware of the concerns, but then brought them in anyway. Then we pulled up a case called Fraser from 2020, which is a case I've discussed in some of my other videos. That is a case that deals with something called adverse impact discrimination. And look, I have my criticisms of the case, but if you watch my video about whether or not math is racist, I mean, it's so crazy to me here that a court in Ontario said teachers don't have to do this teaching qualification test because there's differential impact on different racial groups on their performance of this math test. So it's discriminatory because some groups are doing better or worse than others on this math test. So that's an adverse impact on some of those groups. So it's discriminatory. But then we get all this pushback about whether or not excluding a teenage girl with a disability from society is actually discriminatory or not. And it seems like these principles from Fraser, I mean, it seems like they're used to find certain things unconstitutional, while other things like this discriminatory vaccine passport policy, it's like, oh, well, let's totally forget about Fraser in these cases. So we said that the vaccine passport regime did not treat disabled people, even if they were eligible for an exemption like Erica, it didn't treat them the same way as a vaccinated person. And all of the patients we were working with suffered from social exclusion and psychological harm as a result of these vaccine passport orders. Lockdown measures we know are harmful for mental health, and to get no exemption or even a partial exemption would worsen mental health. And that was in Erica's affidavit saying that this was having an impact on her mental health. So why doesn't the exemption regime just give Erica a QR code like it did to vaccinated people? That's all she was asking for, to be treated the same way. And there is no evidence that a general exemption to Erica would have imperiled public health, that letting her go to her craft fair would have killed people. And the government's own evidence is that it wasn't dangerous, since they ultimately changed the order and they admitted that they were granting blanket exemptions in violation of their own order. And likewise, giving individualized assessments of people's medical conditions, like Sharon and her brachial neuritis, or Veronica and her complex disabilities, giving individualized assessments for off-list medical conditions to make people eligible for exemptions, that wouldn't have imperiled public health either. We already know that public health was granting off-list exemptions, so they weren't concerned about this when they were violating their own law. So We then turn to Section 7 of the Charter, which relates to or guarantees the right to be to life, liberty, and security of person, and not to be deprived of that right except in accordance with the principle of fundamental justice. So we say that this vaccine passport program was a soft coercion that limited options. It all relates to fundamental personal choices, because as more and more options are removed from the path in front of you, the more and more likely you may be to say, I'm tired of this isolation. I may choose to go and make a choice contrary to my own health best interest, contrary to the advice of my doctors, and it could hurt me because the government, if I don't make that choice, is going to keep me isolated. And I remember when I was here a few months ago doing the lower court case, Erica actually told me, I asked her, did you ever, think about going to get vaccinated? And she said she thought about it all the time because she was just sick and tired of being left out of everything. And even though her doctors told her it wasn't safe for her, she still thought about doing that. That is soft coercion. That is the government inserting itself and creating a pressure to change a fundamental personal choice to the detriment of an individual's health. So in Section 7 also guarantees the right to liberty, and that right is also engaged by the public health orders, these vaccine passports, because a term of imprisonment is a possible sanction for the breach of the orders. There's also the notion of this right to roam, which is like I can roam around the world. I'm free to, walk around society and go to public spaces and spaces I've been invited into. That right also engages, that concept also engages Section 7. So we also went through the case law on these principles of fundamental justice. We addressed the government's argument. The government said going into a restaurant isn't a Section 7 protected right, and that social exclusion is a Section 15 issue. But we said that Section 7 is engaged by how social exclusion creates medical coercion. And to avoid discrimination by the government, do you make a choice to the detriment of your health? How much state pressure can someone be under before it engages Section 7 right to security of person? And then we also turn to this concept, if a law claims to create an exemption, if that exemption is illusory. In practice, there's a Section 7 issue. We went through, there's a whole slew of case law related to medical marijuana. There's notably a case from the Supreme Court called Parker that dealt with that. We dealt with the public purpose and the objectives of the vaccine passport, which, as we know from repeated public statements by Bonnie Henry, it was to increase vaccination rates. But on Section 7, if health is a public purpose on one end, health is also engaged by Section 7 in our patients' cases. They all had their health at risk by these vaccines, and that is why Section 7 is engaged here. So at the end, we were wrapping things up. We were making a pleading. What we are asking for in this case is a declaration that the law was unconstitutional and that the rights of the women that we were working for, that their rights were violated. So we went for lunch. I had a really good burger at a restaurant downtown, went back. We closed up a few loose ends, answered a few more questions from the panel at the court. And that was it for us for today. So now there is another organization up called I think they're called the Canadian Council for Science and Public Policy. I'm so sorry if I'm getting the name wrong. It's Kip Warner's organization. I'm not involved in that organization or in that particular appeal, so that's why I came back to give you guys the update from today. And tomorrow morning, I do believe Kip Warner's organization is going to be finished today by the end of the day. And then tomorrow it should be the government responding to our arguments about this case. So I don't know how how the government, I mean, we had a very interventionist court. The panel asked a lot of questions, and I wouldn't necessarily read anything into that. The most interventionist judge is Justice Groberman, and he is notorious for asking a lot of questions. He's well known for asking a lot of questions. Our lawyer Jeffrey has appeared in front of him many times, and he said, you know, I know what to expect from him. And yesterday, Groberman did say, he had a funny comment because he asked a lot of questions, and he really pokes holes in arguments. And he said, I explode at random, and don't read anything into it. It is a personal failing of mine. I think he's joking, but he really knows his stuff, and he really wants to ask a lot of questions. So I've described what the interactions with the court was like, but I don't read too much into the fact that they were asking a lot of questions. I don't want you to read into it either, because we don't know until there's a decision out in, maybe 6 months. So that's it for me. I hope that you liked this summary. It's really cool being here. Last time Erica was here and I got to go and have lunch with her. This time she lives in northern BC, so she didn't come this time. But I want to thank all of you who tune in every day, read my live tweets, and wait for my live summaries at the end of the day. I hope you appreciate all of the work I put into making it feel like you are actually there with me, because I know a lot of you can't. Although there were some people who came up to me at the hearing today who say they follow me on Twitter and follow my live updates. Okay, that's it for me. Thanks, everybody, and I hope you tune in tomorrow.